Class is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to today's session's Differences in Federal, State, and Tribal Reentry. I'm Nan Benally, your moderator for today's session. I'd like to introduce today's presenter, the Honorable B.J. Jones. He's the director of the Tribal Judicial Institute at the University of North Dakota School of Law, where he also teaches Indian law and social justice courses as an adjunct. We are also being joined by Mr. Julius Dupree, policy advisor with the U.S. Department of Justice, Bureau of Justice Assistance, who will be doing a brief welcome and the formal introduction of today's speakers. Just to get some housekeeping out of the way, this is a recorded version of this webinar is going to be made available and we'll post it next week on YouTube, and the link will be provided on the APPA Tribal Repository website. We'd love to hear from you during this time. Feel free to post your questions throughout the session, and we will designate the last 15 minutes to respond to all of your questions. So go ahead and type in your questions as we're going through, and we'll get to them at the end of the session. For those of you who are just now joining us, welcome. We will now begin our session, Differences in Federal, State, and Tribal Reentry. It is a great honor for me to introduce our first speaker, Julius Dupree. Julius is currently a policy advisor with the U.S. Department of Justice, Bureau of Justice Assistance, or BJA. He is responsible for overseeing and managing projects that provide financial and technical assistance resources to the criminal justice field. Areas of focus include the Tribal Justice Systems Infrastructure Program, Prison Industries Enhancement Recertification Program, Tribal Reentry, Tribal Community Supervision Capacity Building, and other efforts that focus on strategies to assist states, localities, and tribes with justice system improvement efforts and the rehabilitation of justice-involved individuals. Prior to working for BJA, Mr. Dupree was a program manager with the Office of Justice Programs, Drug Courts Program Office. In 1996, he began working for the Department of Justice as an employee with the Office of Community-Oriented Policing Services. Mr. Dupree received a Bachelor of Arts degree in Criminology and Criminal Justice from the University of Maryland at College Park. Here's Mr. Dupree.
Thank you, Nan. On behalf of the Bureau of Justice Assistance, I would like to thank you for your interest in the Differences in Tribal, State, and Federal Reentry Programs webinar. A number of tribes face significant challenges in addressing community supervision infrastructure and training needs, as well as ensuring successful community reintegration efforts for individuals returning to the community from prisons and jails. Criminal jurisdiction varies by state and by tribe, and the shape and size of a reservation and other tribal lands can mean counting many counties as neighbors. As such, tribes have members returning to communities from tribal and county jails, as well as from state and federal prisons. Often, tribes do not have accurate information about who is returning from incarceration and when, who is returning from incarceration under correctional supervision and with what resources, and returning offenders' risk and criminogenic needs profiles. And also, information sharing in many cases is entirely dependent on the strength of relationships with neighboring jurisdictions. This makes planning for reentry and service coordination difficult at best. Given the inherent challenges, intergovernmental cooperation and collaboration are paramount to ensuring successful community reintegration. So the purpose of this session or webinar is to raise awareness regarding the impact of legal conditions imposed on tribal community registrants by other jurisdictions, and explain how tribal communities can play a role in the reentry process in light of these legal conditions from other jurisdictions. BJA really appreciates the American Probation and Parole Association, BJA's primary tribal reentry TTA provider, for hosting this webinar. As BJA's training and technical assistance provider, APPA provides varying levels of training and technical assistance to support tribal community supervision and reentry efforts. So lastly, I want to let you know that Nan mentioned some of the financial, the work that I do as far as financial grants and cooperative agreements and that sort of thing. So I wanted to at least let you know that right now on our website, on the BJA website, the Second Chance Act Comprehensive Community-Based Adult Reentry Program solicitation is open. It closes on May 1st, 2018. And so you can, if you want to check that, if you want to review that opportunity and see if you all are, if you're interested in applying, then you can go to www.bja.gov and click on the funding link, and that's going to pull up the reentry solicitation that I indicated, but it's also going to pull up all the other BJA funding opportunities that are currently out and available for you to apply for. So I hope that you find this session informative. Now I'd like to go ahead and introduce Mr. BJ Jones. He's going to be doing the presentation for this particular webinar. And BJ Jones is the director of the Tribal Judicial Institute at the University of North Dakota School of Law, where he also teaches Indian law and social justice courses as an adjunct. The Institute has been providing technical assistance to Indian tribes and their justice systems since 1993. He is also the chief judge for the Sisseton-Wahpeton Sioux tribe in South Dakota. That tribe is the first in the nation to develop a joint tribal state parole supervision agreement to permit the tribe to supervise Native persons returning to the community after parole from the South Dakota Penitentiary, and it was started as a way of lowering the recidivism rate for Native parolees. Judge Jones also serves as the drug court judge for the tribe, and in that capacity has overseen approximately 500 participants in the tribal treatment court and has graduated over 300 persons, helping them avoid state and tribal prison sentences. Judge Jones also serves as the chief judge for the Prairie Island Indian Community and an associate judge for the Standing Rock Sioux tribe and Mandan, Hadassah, and Arikura, tribes in North Dakota, as well as a justice on the Oglala Sioux, Leech Lake Band of Ojibwe, and Flandreau Santee Sioux tribal courts of appeals. Judge Jones is a former legal services attorney on the Rosebud and Standing Rock reservations and is a 1984 graduate of the University of Virginia School of Law. With that, I'll go ahead and hand it over to BJ Jones. Thank you.
Thank you so much, Julius. And this is the first time I've engaged with this particular format for presentation, so hopefully everyone is hearing me okay, and hopefully the session will go well. I also want to echo Julius in thanking BJA and APPA for its attention to these issues regarding reentry into tribal communities. As Julius mentioned, I've been a tribal judge for about 20 years now at Sisseton-Wahpeton, and I'm going to talk a lot about a program we've developed there to lower the recidivism rate for parolees who come back into our community. And I'm not going to talk about that program because I think it's an archetype for other tribal communities. You have to respond to your community's needs in an appropriate cultural way as well as a legal way. But it is a program that, to me, has been able to successfully reintegrate a lot of tribal members into the community. But I think as our tribal justice systems, oftentimes we are gauged primarily by the number of prosecutions we've done, the number of convictions we've achieved. And I agree that's important, especially when there are victims of crime in tribal communities. But the part of the justice system that's oftentimes neglected is, what do we do with individuals who have served their time, paid their debt to the tribal community, and now want to be parts of that community. That's a part of restorative justice that we in tribal systems have an obligation to ensure that we give people the chance to come back into their communities. And we have unique challenges with regard to reentry in tribal communities. And I'll talk about those as I go along with my slides. I mean, basically the three challenges we have that state and federal programs don't is, as Julius mentioned, you know, we have a lot of Native people coming back into our communities from institutions, and we don't really receive notice that these individuals are coming back. We also have another aspect of reentry in tribal communities that you don't always see in other communities, and that is people move into Indian country after being released from institutions, oftentimes in search of a familial tie that will keep them out of the criminal justice system, or a way of understanding and using their culture as a way of helping them to recover. So we oftentimes don't know everyone coming back into the community, and as a result, that creates problems for us. The second problem I'm going to talk about as I go along is we need to integrate these persons coming back into our community utilizing some pretty limited resources. I mean, many tribal communities are tapped for resources just for the individuals who are living in the community now. But we have to expand the resources available to make them accessible to those tribal members who come back into the community and or moving into the community for the first time in order to be successful. And I'll talk a little bit about how we've tried to do that at Sisseton and Wahpeton as I go along. And the last problem I think that we have that distinguishes us from state and federal reentry systems is we have a lot of misunderstanding and myths out there about when Native people move back to tribal communities. And many people who come back from institutions, for example, believe once they move back to the tribal community, they're beyond the jurisdiction of the state that perhaps is supervising them, or even the federal system. And this has resulted in a lot of issues with regard to recidivism or other revocation issues, especially with failure to maintain contact, for example, with state parole or probation agents by Native people when they move back into the community. So these are some of the things that I'm going to visit with you about. I'm also going to talk a little bit about our system that we've created down at Sisseton and Wahpeton, and maybe that will give you some ideas for how it would work in your community. So Travis, if you could move the slides. So what I'm going to talk about is, why is reentry different in tribal communities, and are those differences good or bad for tribal communities? I happen to believe that the individuals that we welcome back into our communities can become valuable contributors to our community, not only culturally, but they're family members in our community. They can contribute to the labor force in our communities. I always tell the story that I've been a drug court judge for 20 years, and my boss at the tribal court, our court administrator, is actually a graduate of our drug court program. She was actually one step away from being incarcerated long-term due to drug and alcohol issues, but she turned that around and she redeemed herself, and now she's actually my boss, which I find that to be a very compelling story about redemption and how people can change. So I'm going to talk about what reentry means to tribal communities, how it's good. It also has some bad aspects because it does drain limited resources. I'm going to talk about how these tribal considerations may differ from state and federal concerns. And I'm going to mention some of the federal, state, and tribal laws that impact reentry. Unfortunately, a lot of people who come back to our communities come back with a lot of legal baggage. There are a variety of federal, state, and tribal laws that impair the ability of these people to fully reintegrate into the community. So we have to have a community-wide approach to how we're welcoming these individuals back into the community for their stay to be successful. Because as a judge, I've talked to a lot of young people who within 2 weeks of returning to the community from prison have violated parole or violated certain conditions, and they're now going back. And when I talk to them, a lot of times they tell me they get out of prison and they became accustomed to a certain regimen or structure in prison. And when they're released, they have no structure. They have no regimen. They have nothing to do with their day. And it's a burden upon us in the community to give them some structure, give them a meaningful voice in the community. Because if we do that, a lot of these people who are coming back to our communities, they come back refreshed culturally sometimes. I've noticed a lot of tribal citizens who've been incarcerated. For the first time, they become acquainted with spiritual practices, ceremonies that they never grew up knowing, but prison actually gave them a chance to learn those things. So they're re-energized and they want to contribute to their community. But if we don't have services for them when they come back, it creates some obstacles for them. Okay, next slide, please. I mean, everybody knows what reentry means. To me, it means coming back from an institution, either a penal institution or sometimes a mental health facility, or even from foster care. We have a lot of young adults who have transitioned out of foster care off the reservation who come back to their community looking for their families. Those people are valuable members of our communities too. We have to learn how to integrate them into the community. And Native people, because they're disproportionately represented in correctional facilities and other facilities, quite naturally, they're also overrepresented in the reentry population. I'll give us a few statistics here on the incarceration rate for Native people. I mean, I'm from a state, South Dakota, where the percentage of natives in the prison is 10 or 11 times it's the percentage of natives in the general population. And that's true for a lot of states. Alaska is like that. Montana, even public law 280 states like California. Native people are disproportionately represented in the penal institutions, and primarily because of drug and alcohol issues. Most Native people are incarcerated for nonviolent drug and alcohol offenses. So that creates a burden upon us to create services for them when they do return to the community. And as I mentioned, we also have an entry issue. People who have never lived in the community move to the community oftentimes after release from facilities. So, okay, next slide, Travis. There are some differences between tribal reentry and state and federal. One of the biggest being we in the tribal communities, because of deficiencies in the laws, don't always get notified when people release from prison or release from other institutions and are coming back to the community. I know under state law, I believe most states notify the local county sheriff when a person is released back into the community. I don't know of any state laws that compel a state to notify the tribal police or tribal leadership of when tribal members are returned to the community. And this creates a lot of problems. In fact, only until recently, when the Tribal Law and Order Act was enacted, was the federal government responsible for notifying tribes of people coming back into the community. Now we'll look at as part of the Tribal Law and Order Act, it does say the federal government has an obligation to notify the tribe of violent offenders or sex offenders who move it back into the community. But that's a small portion of people who are coming back into the community. So we have this unique problem with lack of notice of who's moving in, and that creates problems for us. One of the reasons we started a parole program with the state in South Dakota at Sisseton and Wahpeton was we had a large number of tribal members coming back from the state penitentiary, moving back into the community. And the revocation rate for their parole was very high. And when we asked the state, what's the number one reason for revocation, the typical answer was failure to stay in touch with a state parole officer, because many tribal members get back into the community and think they're beyond the scope of state jurisdiction. So one of the things we wanted to do when we started that program is to make sure that the tribe itself can monitor its own members when they return to the community. And we thought that would lower the revocation rate for tribal members moving back. Another problem that I think we have with reentry into tribal communities is a lot of people still perceive reservations to be fairly lawless enclaves. There's actually a bill pending before Congress. I don't think it's getting much support, but it's called the No Haven for Fugitives Act. I don't know if anyone has read this, but essentially what this bill would do, it would make it a federal offense if you're Indian in Indian community when the state issues a felony warrant for you. So for example, if you're on the reservation and you fail to appear for a state court proceeding and the state does a failure to appear warrant, if that's a felony warrant, under this law, that would now become a federal felony, and you could be picked up by federal marshals and brought off the reservation and returned to the state. Now, one reason I think this bill was proposed is because of this perception that there is no justice in tribal communities and there's no way to get people back into other jurisdictions when they come on the reservation. And this is to me, it's a total myth, because most tribes have effective extradition laws and utilize those laws. I mean, in court on Wednesday, I did arraignments yesterday, and there were 2 individuals who the state wanted. We had extradition warrants for them, and we have an extradition process where we return these folks to the state jurisdiction. So these myths about reservations being lawless, they hurt us all in tribal communities, because they result in laws like this law, which would basically felonize a lot of tribal members who have state charges, felonize them also in the federal system. So it's important we work out these extradition agreements with states, but we have to disabuse people of the notion that reservations are lawless and people only move there to avoid their legal obligations, because that's certainly not true. Next slide, Travis. One other difference we have is when we have tribal members who return to our community and they're under state or federal supervision and they violate the law, then we have this issue with there's 2 jurisdictions that have a responsibility to do something. And we need to coordinate to make sure we don't double punish someone. If someone returns to the tribal community who's on parole, for example, and they commit an offense, such as possession, let's say, of methamphetamine, and the tribe is prosecuting that, and the state is commencing a revocation proceeding, we need to coordinate to make sure we can get the services to that tribal member that are necessary to help that person. One thing we've done, it's just in Wapaton, we started a program where we try to reach out to any tribal member who's in a state or federal facility and who has pending tribal charges. We've tasked our public defender with reaching out to those individuals to see if we can resolve the tribal charges, and we would give them a concurrent sentence with the state and federal sentence. Therefore, they basically are allowed to serve that sentence in a federal or state penitentiary and then come back to the tribe with a clear record. Because nothing's more discouraging to an individual who just gets out of a penal institution than returning to his home on the reservation and having the tribe lock him up. And there's a lot of that goes on. A lot of tribal members, for example, who owe delinquent fines and costs to the tribe when they come back from prison. They've not had the ability to pay it, but they still owe it, and they oftentimes get picked up for a warrant. So we have that obligation to work together to ensure there's no double punishment, but we also have an obligation to ensure that people are held accountable for their violations. Okay, next slide, Travis. Okay, here's some of the reentry concerns that are probably unique to Indian country, and they create, to me, huge obstacles to people succeeding. The notice issue. With the exception of the federal law that requires notice to tribes of people getting out of federal prison for violent offenses or sexual offenses, there's very few state laws that mandate that tribes get notified of people being released from state prisons. Now, I've been told that some states do that as a matter of course, but it's not compelled by the law. We need to know who's coming back. Not so we can follow them around and make sure they're not violating the law, but so we can identify who needs services. Who needs services when they come back? We've been able, for example, at Sisseton and Wahpeton, to identify people coming back. We've been able to start an employment program where the tribe has various economic enterprises that can employ them. We also have a local employer who the employer is actually managed by an ex-con himself, and they've said to us, hey, we want these people to work for us. We want to give them a second chance. But this creates quite a strain on the tribal community because remember, a lot of Indian reservations have a very high unemployment rate. And even the tribal members who live there or are not under supervision have a difficult time finding a job. So when people move back into the community, already with that badge of being a felon or a convicted person, it's oftentimes difficult for them to get a job. And that's one of the first things you're told when you're on parole. You got to get employment. Well, we got to work together in the community to make sure there are opportunities for folks who come back to the community because, again, these are not throwaway people. And if we don't do a good job reintegrating them into the community, the entire community is going to suffer. There could be victimization of persons in the community, but more importantly, the community is going to lose people who could be a valuable contributor to that society. So it's important that we understand these concerns. We try to reintegrate folks into the community. Some of the things we've done, Sisseton and Wahpeton, we've, for example, allowed people who come out of prison to participate in our drug court. Even though many people get treatment in prison, it isn't a culturally based treatment program, and therefore they are in need of more services when they come out. We've also used a lot of people reentering the community from institutions as mentors. We've in our drug court, we've had young people who successfully served stints in prison who come back to the community, and they've been cultural mentors to others. They know more about the spiritual life than a lot of other people in the community. So it's a challenge, but it's a rewarding challenge because these people can contribute to the community. Next slide, Travis. And I love this quote from Attorney General Loretta Lynch. We're not just helping formerly incarcerated individuals to return to the community. We're helping our whole community. These people are mothers, fathers, grandparents, uncles, aunts, and they can contribute to our community in valuable ways. And a lot of them come back and they're really re-energized because there's a sad thing I've seen. A lot of these young people, they don't even find out who they are culturally, who they are traditionally, what their spiritual practices are until they go to prison. And that's where they learn that, and they get this understanding, and they want to come back and share that with other members of the community. So I love this quote from former Attorney General Lynch. These are valuable people. Let's treat them that way. Let's give them that respect. Let's help them, give them a chance at redemption and help them restore what they've taken from the community. Next slide, Travis. There's a lot of baggage, though, that is associated with being a convicted person. And I'm not here to say this baggage isn't justified or warranted, but I've just listed a few statutes here that create significant obstacles to people returning to tribal communities. The Native American Housing and Self-Determination Act, for example, prohibits certain convicted felons from living in tribal housing areas. Many Indian communities, tribal housing is all the housing there is. And so the choice these people have when they come back to the community, they can't go get housing themselves. And if they try to move in with family members who live in tribal housing, oftentimes that may create situations where the family members may be evicted. So we need to look at how we can create communities where people who are coming back can live within our communities and not violate these laws. SORNA, Sex Offender Registry Notification Act. Many tribes now operate their own SORNA programs. And these programs prohibit certain offenders, sex offenders, from living in certain areas in the community. And these are valuable things, valuable laws to protect our communities. But how do we balance that need to protect the community with our obligation to give people the chance to redeem themselves? It's a difficult balance to draw. Tribal Law and Order Act, I'll look at in a minute, does have a provision about notice. There's a law called the Native American Children's Safety Act. This law says that children cannot be placed into homes, foster care, or even private placements where there's certain convicted felons. And so, this creates obstacles also. Maybe there's someone who wants to, when he gets out of prison, wants to go home and live with his mother. Maybe mom has grandkids though in the home, and they can't do that, or the grandkids would have to be removed. So these are all factors we have to look at. There's also some with regard to the temporary assistance of needy family and the SNAP or the food stamp program that may render certain felony drug offenders ineligible for these services, and the Indian Health Service may restrict their access to medications and things if they have drug offenses. So this is some of the baggage we have to recognize exists with people coming back into the community. Okay, next slide, Travis. This is a section of the Tribal Law and Order Act I mentioned that requires the Bureau of Prison to notify tribes that their chief law enforcement officer, whenever a person is being released to tribal jurisdiction, has been convicted of a violent crime, drug trafficking, or sex offense. Now, this is very few people. This is not a majority of folks who come out of Bureau of Prisons and come back to the community. Most people who come out of the Bureau of Prisons are coming out for drug offenses that are nonviolent in nature. So this does, for the first time, require the federal government to give some notice to tribes of people coming back in. Note it does not in any way impose a burden upon the state, though. Next slide. There are a lot of really progressive reentry programs out there in tribal communities. I did a search and I found a few that I list here. This is not an exhaustive list of these programs. There are a lot of tribal communities that are really active in the reentry arena. In fact, I think we can teach a lot to our friends in the federal and state courts and systems about how to reintegrate persons into the community. Tribes have a long history of restorative justice, and one aspect of restorative justice is forgiveness. And giving people the chance to come back into the community and contribute is a traditional thing for many tribal communities. And some of these programs I list here, and a lot of them have websites, are programs that have successfully achieved reintegration for community members coming back. So, and you may know of others that exist. So these are just a few that I've found. Next slide. But we have to have a coordinated response to this issue. We have to utilize all the services we have in the tribal community to try to get back people into the community and create possibilities of success. Give them an avenue for success. I mean, not only in the area of employment, we've got to make sure that treatment services are provided to them. You know, we've got to look at the child support enforcement, for example. You know, I understand people who go to prison, that's not an excuse not to support your children. But I've seen many state laws, for example, that impose these huge financial obligations upon people, even when they're in prison. And when they get out, they have a difficult time complying, and they give up. And we, you know, for tribes who run child support enforcement programs, we need to look at that aspect of it. And again, I understand the counter argument that, hey, these folks, they put themselves in prison. We can't enable them by giving them breaks. But most people who come out of prison, most I've seen, you know, they want to do well. They want to redeem themselves. So we need to give them a chance. You know, in some of the things I've talked about that we've been able to do with regard to employment, with regard to opening treatment services to folks who come back into the community, opening mentoring opportunities. These are just some of the things that tribes can look at doing and welcoming their members back into the community. Is there another slide, Travis? Julius and Nan mentioned that the Bureau of Justice Assistance is funding reentry programs for Native communities. There are a variety of technical assistance providers who are doing good things out there in the community. And I'll list some of them here. Nan is the primary contact for a lot of these service providers, APPA. I mean, we want to make sure tribes don't lose focus on this important part of their justice system, and that is the restorative part of it. Let's give people the chance to make amends and then come back into the community. And I think that's the last slide, but just a few more remarks about our parole supervision program. One of the things we noticed is that the revocation or recidivism rate for Native people was a lot higher in South Dakota than it was for non-Natives. And we couldn't figure out why that was. One thing we were told was that Native people tended to lose contact with their state parole officers when they came back to the tribal community. And it almost got so bad that the state parole board was thinking about denying Native people the right to move on to reservations because of the jurisdictional problems. Now, to me, this represents a fundamental potential violation of a human right to be with your family. But it was a problem the state saw. And so what we said was, why don't you give us the chance to supervise these tribal members? And maybe that will lower the recidivism or the revocation rate. Now, I'd like to say it solved the problem, but it hasn't been as successful as we've hoped. You know, we still have people who come out, can't find that structure, and they continue to violate. And it creates some political quandary for the tribe. Fortunately, in our agreement, we agreed that the tribe wouldn't do the revocation proceeding, it would be the state. But it's difficult for what we have as a wellness team, people who meet on a regular basis to talk about these folks who have been paroled back into the communities. It's difficult politically, it's difficult as a family member to recommend that someone go back to prison. But that's part of being accountable to the state as well as being accountable to the community. Certain people who are not going to conform, they're not being valuable contributors, we have to hold them accountable. So a lot of people have gone back, even though the tribe has been supervising parolees in the system. but overall, I think it's resulted in some positive things. We've even seen the situation where Indians from other reservations are told, well, there's a tribe, and now there are actually two tribes, Standing Rock and Sisseton, that run these programs. Other natives are told, hey, there's a tribal parole program. Would you like to be paroled onto this reservation? So I've seen people in our community who were paroled into the community from other reservations when they committed their crimes. And that creates other problems, of course, but we're trying. The tribe is, I think the tribe has a very positive outlook and attitude towards its members coming back from institutions. So that's, I think, contributed to a success for a lot of individuals. Is that the last slide, Travis?
Yes, it is.
Okay, I think we wanted to open it up for some questions, right, Nan?
Yes, everybody, you can go ahead and start posting your questions now. We haven't seen anything yet, so just go in the chat pane, and you can just type in your questions, and then we'll address them individually. Okay, I think we have one question, so they're starting to come in. So we'll get those out to you. Okay, when an individual is released, why doesn't the state parole or probation do a home visit prior to their release?
That's I think one of the problems, again, is a jurisdictional thing. The state really has no authority to come on to an Indian reservation except in a Public Law 280 reservation and dictate to a family member or a home where that person's going to be released to that it must meet certain standards. Now, I understand the counter argument to that is if the state's not permitted to do that, then the state may not release this person back to the community. But I think the tribe is pretty sensitive about the state trying to impose standards upon its members in a community. But there are some states that do go do those home visits and make sure those are appropriate homes for parolees. But some states don't do that. They, leave it up to the parolee to go find a home and then basically leave it up to the tribe to supervise sometimes. So it creates some jurisdictional issues, but some states perhaps are hesitant to do that.
Okay. The next question is, what was the website for the grants again? She only caught part of it. That was Rachel.
Hi, Nan. This is Julius. That website is www.bja.gov, and then you want to click on the funding link at the very top of the page. It says funding, and then it'll give you all the solicitations that BJA has available on the street right now.
Okay. Thank you. It says, I have reached out to tribal probation and tribal courts to start this dialogue with great success. Who else from tribal partners should I reach out to get that so that I can get a CNA for get the most benefits?
Well, I think many tribes have a treatment program. You can reach out to them. A lot of times there's an Indian Health Service mental health program. I would reach out to the elderly in the community. A lot of tribes have an elderly committee, and these are people who know traditional ways, know cultural values. They may be a good source of contact, interaction. The tribal government, the tribal council, they're very interested in seeing successful reintegration of their members into the community. Reach out to the Tribal Child Support Enforcement Program too, because again, a lot of these guys who come out of prison have some pretty onerous child support obligations that maybe something can be worked out for them. The more programs you reach out to, the more integrated the plan can be to make it successful. So I'm glad to hear that you're having success reaching out to the court and probation, and hopefully there are other tribal programs that are vested in reintegrating that person into the community.
Okay. And then from Jerry, are there some templates for MOUs and MOAs?
There are a lot. I mean, I can share with Nan the agreement we have with the state. Again, not to say this is the ideal thing. I hate when I hear people say this is the only way to do it. You gotta do what your community needs. But I mean, I've seen some agreements about monitoring state offenders by the tribe, and vice versa. The state monitoring people on tribal probation. And I can send Nan, some of the ones that we utilize, and I'm sure maybe there are others on the call that have good interjurisdictional agreements regarding monitoring people.
Okay. And then many times the tribe will not allow parolee to turn to Utah, which is Navajo, the Navajo res. He was an SO. When can he return home? Upon discharge and off paper only?
This is a great question, and I've heard this from a lot of tribal communities that some state parole boards will not allow tribal members to return to their community because of the jurisdictional problem and getting them back off should they violate. I've even seen judges refuse to bond people into tribal communities because of the problem with getting them back off should they refuse to come back off. But most tribes, and I think the Navajo Nation has an extradition law that allows people to be extradited off. I think it's a fundamental human rights problem if you're not allowing a person to go back to their family after parole because of a fear that you won't be able to get them if they violate. And but I've seen that in other states. I've seen a requirement that you have to go to a halfway house in a large urban area in South Dakota, Rapid City or Sioux Falls, South Dakota, and a lot of these folks don't do well after release because they don't have that family. So I understand the state's concern, but I think if you talk to the tribe and find that they have an extradition law, that should allay that concern.
Okay. Next question is, the issue is that there are so many jurisdictions, state, county, tribal, parole, federal, all trying to do the same thing, supervise offenders. Do you think BJA will be open to plans that encompass providing funds to multiple agencies, all listed in one grant request?
Sounds like a Julius question.
Julius, did you get that? He might be on his mute.
I'm sorry. Sorry, Nan. Could you please repeat that question? Sorry.
Sure. It says the issue is that there are so many jurisdictions, state, county, tribal, federal, all trying to do the same thing, supervise the offenders. Do you think BJA will be open to plans that encompass providing funds to multiple agencies, all listed in one grant request?
I think that's a really good question, and that's something that I'm not sure. We do provide reentry funding, and we provide funding, but it's funding that either goes to the tribes or to the state, and so to the extent that I would have to look into that. Actually, I just don't see. It could be there could be one applicant, or one applicant that would be the primary applicant, and then you could contract with other entities. That's one way to do it. But for our grants that are we have a grant for the tribal reentry. Under CTAS, you can apply under the coordinated tribal assistance solicitation, you can apply for funds to do reentry, but if the tribe would actually be the primary applicant, and then whether the tribe wants to consult with other entities, then that's up with the tribe. Same with the reentry, the Second Chance Act, which is not tribal specific, but tribes are still eligible. Again, we would have to have a primary applicant. It could be a local jurisdiction or or not nonprofit. Well, I think under the Second Chance Act adult reentry program, it's got to be either a nonprofit or a tribe would be the primary applicant, and then you could maybe contract with other entities as appropriate. So hopefully that helps, but it's not it's one of those deals where we have to have a primary applicant, and then tribes can contract with other entities as needed.
Okay, thank you for that. Next question is, oftentimes adult and probation parole will attempt to make appointments with the tribal government office to see if they would be willing to cross-collaborate with APPO in terms of allowing officers on their land when field calls need to be conducted. Tribal officers will often accompany APPO when conducting home visits on tribal members, New Mexico anyway. Is there a way to merge tribal and state probation so that there isn't a lost connection with the probation officers?
Well, I think you'd probably have to use the cross-deputization model where counties and tribes have cross-deputized law enforcement so that tribal law enforcement can perform duties as a state or county officer, and vice versa. State or county could perform duties as tribal. Maybe there could be a cross-deputization type agreement for probation, because I think it is a big problem when there's a perception that there's a jurisdictional obstacle to state or county probation doing its job. That may result in the individual being punished and revoked. So I think you can use the sort of the cross-deputization model for probation too, and I'm almost positive there are tribal and county probation that are cross-deputized and do things like that.
Okay, next question is, will BJA fund peer support groups and community support groups that wish to help create reentry centers? Julius?
Yes, this is Julius again, and the answer to that question is under the Second Chance Act. I know we have there's the current adult reentry program that's out there. You can actually apply for funding under that to be able to provide those kinds of services. So yeah, the answer to that question is yes, under that particular solicitation. And if you were to apply for the coordinated tribal assistance solicitation, which is now closed, that's another option as well. But we won't offer that opportunity probably till the fall of next year. So the best bet right now is to really look at that application, the Second Chance Act one that's closing on May 1st to do that top kind of work.
Okay. The next one is, let's see here. The Yavapai Tribe, Yavapai County, Arizona will not allow more than one individual on probation parole in a home. How can this be remedied?
Yeah, and I can't speak to whether that's a byproduct of state law or whether that's just the policy of that particular county, but it again creates a huge problem in some tribal communities where there's maybe grandma's head of household and she's got several kids and numerous grandkids, and that's not unusual in tribal communities. But I think that's in a way that the state has possession of the person through parole or other supervisory authority. they can impose reasonable standards. Now, that's probably a standard that would be upheld by the courts, but maybe the tribe in that situation could say, if you would let more than one person on parole live in a home, we'll help with services to those folks, and we'll make sure it's a successful venture. But I understand that's a typical condition of parole. You cannot live with another person on parole or a person who's been convicted of a felony, and that sometimes creates obstacles to coming back to the tribal community. So I can't say that's an illegal policy, but perhaps the tribe has some resources available that they can help monitor to, and maybe that policy could be bended in certain cases.
Okay. Another question. Oftentimes, adult probation and parole will attempt to make appointments with the tribal governments, with tribal government offices, see if they would be willing to cross-collaborate. Let's see, I think we've already done that one. That might be, that was on conducting home visits on tribal members. So they're just asking about, when their field calls need to be made, and that's a jurisdictional question. So I think they're just commenting on that. And I don't know if I have any other questions at this point. Okay. Okay, it looks like we're all at the end of our time. If anybody have any other questions, we'll wait just a couple more minutes and see if we have anything else. Okay, it looks like that nobody else has any other questions. Well, at this time, I would like to thank our guests, the Honorable Judge B.J. Jones and Julius Dupree. Also, thank you, the participants, for your responses and for attending this webinar today. We'd also like to take this time to extend an invitation to attend our next webinar, which is titled Impact of TLOA and VAWA with Michelle Parks from the University of North Dakota Tribal Justice Institute. That webinar will be broadcast on May 10th at 3:00 p.m. Eastern Standard Time. We will send out the information for registration for this session next week. And again, as a reminder, this session has been recorded and it will be posted on YouTube. You can access that information on the APPA Tribal Repository website. That will be posted next week for you to be able to listen to and listen back in on again. So thank you, everyone. And if there's no other questions or any other comments, do you have any? Do you, Julius or BJ, have any other last comments you'd like to make?
Nothing from me.
Nothing from me. Just appreciate everyone's attention and contribution and interest in the topic.
Okay. Thank you very much, everyone.
Bye now.
Thank you.